Well, my lady, my lords, if I can now turn to the appeal in respect of the determination of habitual residence. I've already outlined in brief what our summary is, that Mrs. Justice Hogg applied a gloss rather than the primer in the assessment of habitual residence, which when she did apply a primer on top of the gloss, it didn't really stick very well. If I can take as a starting point what was accepted before Mrs. Justice Hogg, which was that both B and the respondent mother were habitually resident here, and that therefore the issue that Mrs. Justice Hogg was assessing was whether that established habitual residence had been lost. The Court of Appeal approach to upholding Mrs. Justice Hogg's determination is at paragraph 30 of their judgment at MS 305. And the Court of Appeal there held that she approached the question of habitual residence in line with authorities, conducted a factual inquiry, focused on the correct meaning, and there was no evidence that she was deflected from contemporary methodology by anything in Re J, with the ultimate conclusion in the last three lines. In short, she applied the proper principles to the relevant facts, and there is no reason to interfere with her finding that P lost her habitual residence here when she left for Pakistan. I hope that we can demonstrate in the course of my submissions this afternoon that in fact the judgment of Mrs. Justice Hogg was dominated by considerations emanating from Re J, and in particular was dominated by the intentions of the mother, the respondent mother, and the derivative habitual residence that a child takes from a parent according to Re J. The appellant mother's case on the facts and the law, as it was put to Mrs. Justice Hogg, can be found in Appendix 3 at MS 508 and MS 559, and at MS 508 if I can, as it were, look at the factual case that was put to start with. Mr. Perkins set out at paragraph 21 on MS 508 a number of facts which were relevant to the assessment of habitual residence. And at MS 559, which were the closing submissions, at the bottom of page 558, it appears particular regard should be given to, and Mr. Perkins set out then items A to J, and then at paragraph 9, a further two factors which it was submitted were relevant to the assessment of habitual residence, and included within those, of course, were the duration of time spent in England and Wales and away from England and Wales, the fact that it was B's first trip to Pakistan, the conditions of her living conditions when she first arrived. Now, only one item in that list at D is the reasons for the stay or move. And here we see Mr. Perkins referring to whether this was a pre-planned move or a hurried flight from impending litigation. He then returns to the fact that B was British, the schooling, linguistic knowledge, family and social relationships of B, comparing England and Pakistan, the fact that B was at school, the desire to, or the anxiety that B had that she wouldn't see the appellant mother, reference to integration not being possible to be looked at without reference to the past, and then over the page further issues to do with integration, comparative issues of integration in social and family environment, and another reference to the reasons for the move. So that was the sort of issues that Mr. Perkins was inviting Mrs. Justice Hogg to take into account. When Mrs. Justice Hogg comes to summarise the appellant mother's case, which appears at paragraph 15 of the judgment at MS 325, we see a wholly different picture emerge of the way the case is said to be put by the appellant mother. So Mrs. Justice Hogg summarises the case as the applicant says...
Sorry, can you give me the page again?
It's MS 325, my lord.
Yep.
Paragraph 15. The applicant says that habitual residence for the child was not lost because the mother's motivation is something I need to look at. That she says the mother was running away from her from the contact and potential litigation, and that she was keen to deprive the applicant and B of a relationship, and that it was a continuation of the way she had behaved in the preceding 2 years. She says it is a running away and was not a carefully planned departure. She says that Zahara was still integrated in England and Wales, that she had written a note to her for Christmas saying, "I'm missing you, me." According to the applicant, her mother does not accept it. During the last visit, it is said that B told the applicant they were going away. She was sad and scared that the applicant wouldn't be able to find her, and very clearly the applicant, through counsel, says, I need to look at the situation from the child's point of view and her position. So there one sees only really 2 of the factors which were rehearsed by Mr. Perkins set out in any detail.
Well, I'm sorry, what did Mrs. Justice Hogg mean by saying, according to the applicant, her mother does not accept this? What was the mother, the respondent mother, not accepting?
I think, although I'm not sure, my lord, that this is a reference to the respondent not accepting that B had said, I am missing you, Mimi.
I thought that was in the note.
Yes, that is the note.
But she can't argue with a note, and she can't challenge what your client was saying was said during the contact visit.
No,
It's the running away. Well, there it is.
Perhaps it's the running away.
Move on.
Yes, so that's the judge's summary of the way the appellant mother's case was put, which we say isn't really in any sense a full summary of it. But when we see what Mrs. Justice Hogg subsequently founded her decision on habitual residence on, we can see the link between the two. And I'll come back to that in a moment. If we then look at the way the law was put before Mrs. Justice Hogg, we start with the way Mr. Perkins summarised it in his note, which is at MS 504 onwards. Mr. Perkins started with what we would say is the absolutely correct starting point post this court's decision in A&A, when he referred first of all to paragraph 54 of that decision, which is the drawing of the threads together. the natural and obvious starting point. He referred to then the second of the three Supreme Court cases, KL, set out at length some of the extracts from that, and then at paragraph 19 referred to RELC. The respondent mother adopted, in essence, that summary of the law at page MS 549. We have the respondent mother's summary of the law, starting at paragraph 33, MS 549. Again, first reference is to REA, different name, same case. Reference to the European authorities. At 35, reference to what we say actually is now perhaps the essential distillation of the approach, where one is looking at the loss of habitual residence, is paragraph 63 of RELC. And over page at paragraph 37, the respondent mother specifically adopts Mr. Perkins' review of the recent jurisprudence and adds some further reference to this court's decision in LC. And if one returns then to Mrs. Justice Hogg's decision at MS 326, and bearing in mind at this point that neither Mr. Perkins or Miss Markham had referred to Re J at all in their notes, the starting point is identified by Mrs. Justice Hogg at paragraph 16. I refer now to the law, which has been clarified in the recent past, starting with Re J. Well, it certainly, Re J was not the starting point in terms of clarification, but that's the starting point. Now, it's right to say that Mrs. Justice Hogg raised the issue with Mr. Perkins in the course of the hearing, the relevance of Re J, as a result of which Mr. Perkins filed a further document before closing, which appears at page MS 556. And at paragraph 2, Mr. Perkins says, the writer has previously provided a summary of the three Supreme Court decisions clarifying the approach that this jurisdiction is now bound to adopt in relation to the determination of habitual residence. Paragraph 3, this court has invited the writer to reflect upon the impact on the particular circumstances of this case of Lord Brandon's observations made in Re J. And so this is a wholly judge-led introduction of Re J into the legal framework. And in the course of dealing with Re J at paragraph 4 in particular, Mr. Perkins refers to what this court had to say about Re J in A&A, in KL, and in RELC. And if we then look at Mrs. Justice Hogg's judgment, starting with Re J, we see that almost the entirety of the summary of the legal framework is dominated by Re J and what this court said about Re J, the references which Mr. Perkins brought to her attention. So we start with Re J at paragraph 16, we then move on to paragraph 17, and she refers to paragraphs 72 to 75, which are those which Mr. Perkins refers to at his paragraph 4. So those all appear, and they're all talking about Lord Brandon's generalisations. At paragraph 19 of Mrs. Justice Hogg's judgment, she refers to paragraph 44, which again is the one referred to by Mr. Perkins at paragraph 4a, again dealing with Lord Brandon. Paragraph 20, she deals with KL. At paragraph 20 and 21, again, those are the ones which Mr. Perkins referred to in his submission as being focused on Re J, and again, one can see that all the way through, it's all considering Re J. And then at second paragraph 21 on page 328, final case LC, Lord Wilson at paragraph 33 said this. That again comes from Mr. Perkins's response to the judge asking him to reflect on Re J. And if one follows through over to the next page, 33, 34, Baroness Hale appears at paragraph 24, where she refers to part of paragraph 61 in Re LC. She doesn't refer to the other parts of LC, and that is essentially where her summary ends, save for the reference to Mercredi and Chaff. Now, if one analyses that judgment, of the references in the judgment, 16, 17, 18, 19, 20, 21, 22nd 21, 23 and 24 are all about Re J. The only ones which don't focus on Re J are part of paragraph 1 paragraph 21, and paragraph 22, which is about the fourth generalisation, and then paragraph 25. And we say, crucially, it leaves out paragraph 54 of Re A, the starting point, the natural starting point, but also, most importantly, paragraphs 63 and 64 of Re LC. And if I could invite the court to consider those parts of LC which are in volume 8 of the authorities. At MS 3291. Now, so if one was to look at what Re J had to say about losing a habitual residence, it's a considerable focus emerges when Lord Brandon says a person may cease to be habitually resident in country A in a single day if he or she leaves it with a settled intention not to return to it, but to take up long-term residence in country B instead.
It's a very unusual judgment because there is no citation of any decided case, is there, in Lord Brandon's speech. So where did he get that from, Mr. Williams?
It's very interesting. I was looking at that last night, my lord, to try and work out where that did come from, because Shah, of course, doesn't appear in there. So it's not even one of the cases referred to. So where Lord Brandon, the precise provenance of Lord Brandon's propositions, I can't identify where they originate from. But of course, we know that those propositions, as this court identified in the trilogy of cases, were best looked at as generalisations of fact. But if one is going to ask the critical question, as one had to in this case, had B lost her habitual residence, we say that actually the proper question that Mrs. Justice Hogg ought to have asked herself, and the proper starting point, was paragraph 63, because that is, if there is a parallel of Lord Brandon's third proposition, it perhaps is in paragraph 63. The quality of a child's stay in a new environment in which he has only recently arrived cannot be assessed without reference to the past. Some habitual residences may be harder to lose than others, and others may be harder to gain. If a person leaves his home country with the intention of emigrating and having made all the necessary plans to do so, he may lose one habitual residence immediately and acquire a new one very quickly. If a person leaves his home country for a temporary purpose or in ambiguous circumstances, he may not lose his habitual residence there for some time, if at all, and correspondingly he will not acquire a new habitual residence until then or even later. Of course, there are many permutations in between, where a person may lose one habitual residence without gaining another. Now, we say that the omission of that, the essential paragraph dealing with loss of habitual residence, is crucial to the way Mrs. Justice Hogg ultimately decided the matter. Because if one then turns to the questions that Mrs. Justice Hogg asks herself at paragraphs 27, 28 and 29 of her judgment, MS 330, in paragraph 27, she sets out some of the evidence she considered, particularly in relation to the mother. Clearly, I must look at the facts to determine the issues. The issues relate to habitual residence, and in particular Zahara's habitual residence. Well, she's right to there. It's accepted that she was habitually resident here up until she left the jurisdiction. Of that there is no doubt, but did she do that as she flew away? Did she acquire a new habitual residence, or did she have none? And then she sets out essentially the respondent mother's intentions, the intention to start a new life. She and B said their goodbyes. They left their home, packed up possessions. She had the intention to set up a new life. She had lost her job. She was finding it financially difficult. She had laid the ground for a new life in Pakistan, all focused on the mother and primarily her intentions. She then goes on to set out what the mother did on arrival in Pakistan, most of which is not relevant to the assessment of habitual residence as of the 13th of February, because the dates post-date the 13th of February. And she summarises her finding at paragraph 28. As I have said, I am not satisfied she was running away, as alleged by the applicant, and this harks back to Mrs. Justice Hogg's summary of the way she said Mr. Perkins put the case. And I accept her intention that she intended to create a new life for herself and for B in Pakistan. On that basis, she lost her habitual residence here. Now, summarising it in that way seems to place a very, very heavy emphasis on the intention the respondent mother had to create a new life for herself. And the origins of that are to be found, of course, in the third proposition in Re J. If a person leaves a country with a settled intention not to return but to take up long-term residence in country B instead, habitual residence may be lost in a day. She then goes on to consider B's position. She's right that the respondent mother was primary carer throughout her life. She's right to say that she said her goodbyes. She's right to say that she would miss Mimi and that she wanted to keep in touch. But then the way Mrs. Justice Hogg phrases the issue is this. The mother is her primary carer, and the wish in B to keep in touch with the applicant is only natural. But is it being the desire to keep in contact, enough to create her own habitual residence or continue her own individual residence in this country? So there she seems to also to be focusing on a question of a subjective question or intention or the child's state of mind. And that is all she identifies as being relevant to the question of whether she was going to lose her habitual residence. And she then goes on at paragraph 29, I must look at the facts. And what facts does she look at? Fact 1, the mother is the sole legal parent. In moving, she had planned a life away. Intention. It was not a wrongful removal, well, a legal fact. She was exercising her parental responsibility. B's wish to remain in touch is something I must consider. Doesn't necessarily mean she has to remain in the country. Children remain in touch with families even when they're relocated. This is another relocation. And then her conclusion, in my view, her wish to remain in touch with the applicant does not justify making or continuing an individual habitual residence in this country when the mother has abandoned her own. Language redolent of intention, perhaps even some hints of domicile there. But it all harks back to Re J and the mother abandoning her habitual residence because she left England with a settled intention not to return and start a new life in Pakistan.
Well, are you submitting that it's not possible to abandon a country of residence overnight, so to speak?
No.
Right.
We would endorse. Who are we to endorse? The summary at paragraph 63 of ReLC we accept as being
That's what I understood. But your criticism of this passage on the face of it, is a finding that what you accept as possible was the fact in this particular case.
We say that if one looks at paragraph 63 and compares it with Re J, third proposition, there is a much broader inquiry encompassed within paragraph 63, looking at the past, looking at the future. If one looks at what else is referred to in paragraph 60 to 64 of ReLC, one is looking for all of the objective and subjective markers of habitual residence. And when one is particularly looking at the loss of habitual residence, one is looking to see which of those markers of habitual residence have been lost, which of them still remain. It is not a focus solely on intentions or state of mind. It is a much broader inquiry. And in this case, if one goes back to what Mr. Perkins was saying in support of the proposition that B had not lost her habitual residence in a day, he was saying she's lived here all her life. She's British. She speaks English. She doesn't speak Urdu. She's been at school here. She has friends here. She's a school-aged child. She's not an infant who is...
To refine my question, are you submitting that it wasn't possible for this respondent to abandon her habitual residence overnight? though it might have been possible for others who were less integrated to do so. Is that the argument?
For this child, for B, our argument is that it was not possible for B, in the circumstances of her move, to have been so rapidly de-integrated in England that she lost her habitual residence as she flew out of British airspace, effectively.
Is it relevant to that question what objective possibility there was of her going back to England?
That could be part of the equation.
But
What
if
was
there
left
none,
in...
If there was no objective possibility of her returning, how relevant is the fact is the past in that situation?
It's hard to answer that in a theoretical way.
Let's do it by reference to these facts.
But in these facts, we know that left behind in England and part of her integration in a social and family environment in England prior to the 4th of February was her other mother. Both sets of paternal grandparents, all aunts and uncles and cousins of relevance, her school friends. So all of that remained and could be reintegrated into instantly.
Yes.
The house which she lived in remained.
How relevant is that? If it were the case that the mother had definitively decided not to return, how relevant is it that if she had wanted to return, there was plenty to return to? I mean, these are factors that may cause one to say, well, she can't have definitively decided not to return. But on the hypothesis that she did decide that, why does it matter whether there was something to return to if she had no intention of doing it?
Well, because one is looking at B's habitual residence separately from her mother's, and one has to look at factors which are relevant to where she is integrated, not just the mother's integration. And if we don't say that the fact of the respondent mother's loss of habitual residence, if that was an accurate determination, is irrelevant. It is relevant. But it is not the only consideration. If one factors in all of the other matters that Mr. Perkins had trailed in his documents, there would have been a more balanced comparative exercise in which one might have seen Mrs. Justice Hogg considering that all of B's cultural influences to date had been English, that her language was English, that her family and her friends all lived in England, that her schooling to date had all been English, that she had never been to Pakistan before, that she was going to a culture and a language which were very, very different to that which she had experienced to date. And all of those matters would have some impact, we say, on whether B de-integrated in England in the course of a night. And of course the 10-day period is less than the average holiday. Of course the intentions are relevant to B's loss of habitual resident, but they are not the be-all and end-all. And that, we say, encapsulates both that this was a reliance on the third generalisation in Re B, together with the fourth generalisation that B derived her habitual residence essentially from the mother, notwithstanding, in this case, that she was not a completely dependent child. She was a school-age child and therefore had a wider social circle. And but if one had started with paragraph 63, that paragraph, we suggest, would be very differently expressed and would take into account a far wider range of factors than it does. If we are right in that, we submit that the proper starting point should always be in the assessing habitual residence of any sort, whether it has been lost or acquired, is this court's decision in A, when one is looking at loss of habitual residence, the starting point ought to be paragraph 63 of this court's decision in LC. In an ideal world, Re J, we would submit, should be put to one side on the basis that it draws its influences almost certainly from an approach to habitual residence which has now been disapproved by this court, and that insofar as it talks of not just the loss but acquiring habitual residence and the need for the passage of an appreciable period of time, it is simply wrong now.
I mean, Lord Brandon must have been thinking in terms of integration as the test, because otherwise it's difficult to see on what basis he could have supposed that it's easier to lose a habitual residence than to gain one. That only makes sense on the footing that you can unplug yourself from your existing environment,
Yes.
but plugging yourself into a new one takes time.
Yes, that is the way he puts it, although I think in this court, in A&A, this court also recognised that in fact you can plug into a country very quickly as well if you have particular links with it. Of course, it's all ultimately a question of assessing the facts in individual cases, but the previous test put a much higher premium on intention and a much perhaps lower premium on objective markers, and almost no premium on subjective aspects of integration. Of course, in Shah, one had the court in that case saying that in judging habitual residence, one would look at objective issues rather than intentions, and this court disapproved of that approach, I think, in my Lord Wilson's judgment in LC. One does look at subjective, one does look at objective markers, one should carry out a comparative exercise. What appears to have happened in this case, and perhaps not surprisingly given the preponderance of reference to Re J, is that Mrs. Justice Hogg identified a proposition that you could lose habitual residence in a day if you left with a settled intention. She found that that's what the mother had done. She also relied on the fourth proposition in Re J, that a child essentially takes its habitual residence from its mother if it's young.
How old was J?
J, I think, was 5 as well. I'll check that, in fact, in Re J, just to... it's in...
Re J, the child was 2.
I thought we gave
sorry.
the child was much younger. Yeah.
Yes, sorry, you're absolutely right, my lord, it is.
I think Lord Brandon is
3, I think.
3.
And Mrs. Justice Hogg fit the facts into the propositions, we say, rather than looking at, with an open, as it were, an open mind and applying paragraph 63. The questions she posed for herself really tell their own tale, and that led her to a conclusion which on its face is a surprising one anyway. Again, if one inverts the proposition to hold that a child who has lived in this country all their lives and has left behind their other parent here in a covert removal in which the child plainly is anxious that she's not going to be found, it's highly unlikely, we say, as a generalisation of fact, that such children are going to lose their integration overnight. This is the sort of case identified in paragraph 63 where the departure is somewhat ambiguous, certainly from the child's point of view, even if the respondent mother was clearer. And in those circumstances, the conclusion seems to sit ill with the factual scenario. If one had B going to a country where she had a home, where she had relatives, where she spoke the language, where it was a familiar cultural environment. Of course, one might see that the dislocation, the disparity between the two would not be so great. It would be much easier to draw up the roots from England and to start putting them down in the other country. But in this case, the two sides of the equation are so disparate that it seems improbable that one could say she had withdrawn her roots sufficiently to end her habitual residence as she exited British airspace. I see that I'm nearly at 2:45 and have used my time. I haven't left anything for Mr. Perkins to add anyway, but that I think summarises our arguments in respect of habitual residence in any event.
There's one point that we did for a while have a rule, a judge-made rule, that where two people had parental responsibility, one of them could not change the child's habitual residence unilaterally. That was disapproved on the basis that it was inconsistent with both the assumptions made in the Family Law Act and in the international conventions, which obviously take into account that a child's habitual residence can be changed, including can be changed after an unlawful removal,
yes,
or a wrongful removal, depending on how you term it. Now, once you take that out of the equation, does the approach to the change of habitual residence have to be the same whether or not the removal is wrongful? And if that be the case, then is it a concern to the whole child abduction retrieval remedy system if this approach, the approach used by the trial judge in this case, were to be applied not only to lawful removals like this, but also to wrongful removals? Sorry, a long question, but I wanted to make it clear what I was thinking about.
Well, clearly this sort of approach can lead to, if applied universally, would lead to very swift loss of habitual residence and thus the potentially shift of jurisdiction with the child, which could create problems in terms of child abduction. Of course, I'm conscious that Reunite in their intervention have really identified this as an area of concern, and hence their invitation to this court to, in effect, replace the Lord Brandon's propositions with another generalisation of fact, which is that in most cases there will be a seamless transition of habitual residence from one country to another, and a habitual residence will not be lost in one country until it has been acquired in another country. That is a proposition which certainly would serve children's best interests, and it certainly would act as a brake on the loss of habitual residence and the shifting of jurisdiction to another country, which Milady identifies as a concern. I mean, ultimately, if one applied the method endorsed by this court in A&A and LC rather than the Re-J method, if one applied that in every case, one would always get a much more nuanced, balanced, comparative exercise looking at the subjective and objective markers on both sides of the habitual residence divide. And one wouldn't find, as one finds in this case, loss of habitual residence in a day, save in consensual moves. Because, of course, if a family up sticks and relocates to America, mother, child, all pre-planned, everything done which one would expect in a planned move to draw up the roots in the country of original habitual residence and to start to put down the roots in the new country, the acquisition of a home, schools, perhaps move to a place where there are family. In those sorts of cases, yes, one can see that it's possible that habitual residence will be lost quite quickly, but also gained quite quickly. But it's only in those planned cases of consensual moves where all of the objective and subjective markers come together to lead to that result. In a non-consensual move, whether it's lawful, as it is in this case, or unlawful, you are likely to find that for the child in particular, there is a degree of uncertainty or ambiguity which is likely to lead to them not losing their integration here quite so swiftly.
Is the answer to that question necessarily the same in a lawful and in an unlawful removal case? I mean, the essence of the wrong in an unlawful removal case is the removal from a place where the child was habitually resident. And that may be a very important consideration in deciding what test to apply, which would not necessarily be relevant in a lawful removal case like this one.
Well, I think that this court made observations in the L case about the impact of whether the move is lawful or not, and I think in that case the court adopted a submission made by Reunite that the difference it makes is that in an unlawful removal it is likely that subjective and objective markers will be more ambiguous in whether they've been lost or not, or gained, because a child who's been abducted is likely to have been uprooted rather forcefully from an environment and thrust into a new one, which is likely to lead to them not having lost their integration and not having acquired their integration in the same way. So the lawfulness or unlawfulness does sound actually in the facts themselves, and it doesn't. I don't think a different test is needed. It just needs to be recognised, as this court has, that it is a comparative exercise, and one needs to look at all the relevant facts, not to focus, as we say, it has happened in this and would happen in other cases by using Re J.
We're looking at the child's habitual residence and not the primary carers. Is it relevant to take into account the position of the various people who form members of the family unit?
Yes.
On the one hand, you could have a situation where all members of the family unit emigrate by planned arrangement. On the other hand, you may have a situation where the primary carer goes of their own particular decision at a time when other members of the family unit are not supportive, and those roots will be broken. Are they relevant factors when looking at whether objectively the child has lost the connection necessary to be regarded as habitually resident?
We say absolutely, my lord, because one is looking at integration in a social and family environment, and if the totality of the family environment moves with the child, and large parts of the social environment move with the child, that clearly would lead to the child losing integration in England more quickly. On the other hand, if the other most significant part of that child's family remains in England, one has we say, continuing strong connection, strong form of family integration remaining in England. I think in the Court of Appeal we had the image of Beatrix Potter and Father Brown or somebody trying to pull up a turnip and Peter Rabbit hanging on to the other end, and that's the sort of tension.
Mr. McGregor.
Mr. McGregor, sorry, it's Mr. McGregor. we have that's the sort of situation where you have these gravitational pulls back to England, preventing the child being removed seamlessly from integration in England and travelling to another country. So that's so absolutely we say that's relevant, and it really doesn't feature properly here.
Thank you very much. Mr. Perkins?
I we follow what Mr. Williams says. Thank you.
Yes, Sister.
My lady, my lords, I seem to recall it was the president of the family division who corrected Mr. Williams last time when he got the wrong farmer plucking the carrot from the ground. Perhaps that will sink in this time. If I may, I will approach the issues in the opposite order to that of my learned friend. After some introductory comments about the case and some remarks about jurisdiction generally, I'll look at habitual residence this afternoon. If time allows, I will look at territoriality, and tomorrow afternoon, I think it is, we'll deal with parens patriae. My lady, my lords, as one mounts the appellate ladder, there's a danger that at each rung, the case, as it appears to the court, bears less and less resemblance to that actually at first instance.
It's a phenomenon with which we are familiar.
Yes, quite.
One to be guarded against, though, I agree.
Our written documents and my oral submissions would in large part seek to ground the case with reference to what in fact unfolded before Mrs. Justice Hogg, to the facts as they were pertaining to these particular litigants, to this particular child. We say, and I'll develop this in due course, that many of the submissions, both of the appellant and of the interveners, have a tendency to refer to an almost different case, a different set of facts, a different family unit, in fact, to that pertaining in this case. In doing so, I'll refer to the facts as found by Mrs. Justice Hogg. It's important, if I may, to note that there was a 2-day hearing in this case in the High Court before an extremely experienced High Court judge. It wasn't a rushed hearing, it wasn't emergency ex parte. There was plenty of time to prepare for it. Submissions, statements, etc. were filed. And there were no time constraints. I understand it overran rather than anything else. There were no guillotines imposed on evidence or submissions. And of course, both litigants gave evidence. The mother, though, it is right to say, she didn't comply with a direction to come to the country, preceded that by seeking to persuade the court to rid her of that obligation, but to allow her to give evidence by telephone. And give evidence by telephone she did. It's also right.
There was no video link or anything like it. It was a purely
telephone.
Oral, A-U-R-E-A-L.
Yes, my lord. And of course, both parties, but I focus particularly on the appellant, were represented throughout by extremely experienced junior counsel. Thus it was that Mrs. Justice Hogg heard all the evidence and all the submissions that either party, through experienced counsel, thought were relevant to the questions then for her ladyship. And those questions were clearly flagged up as being habitual residence and the jurisdiction to make a return order. Not just jurisdiction, whether to make a return order. It's clear that evidence and submissions didn't simply focus on narrow legal criteria or particularly narrow factual issues, but that evidence, cross-examination and submissions focused in particular on the exact nature of various relevant relationships, on the mother's motivations, and on the child's position, both in this country and in Pakistan. It's clear that with the benefit of that evidence, tested as it was, the learned judge was more than able to reach factual conclusions, to make findings in relation to many of the factual elements of the case, and most importantly, in relation to the questions of the nature of the relationships, the relative importance of the relationships to the child, and the mother's motivation in relocating. Now, whilst we set out some of these in our written case, it's perhaps worth, not least because they haven't thus far been expressed before the court, to set out some of those factors which might serve to put the case as in fact it proceeded in a different light. The mother and the appellant, we know, never entered a civil partnership. The child was born in April 2008. Lady, my lord.
Incidentally, I believe the learned judge must have been mistaken when she said that the child was conceived by IVF.
Yes.
It was IUI, wasn't it?
Yes, yes.
Yeah.
If my lady is looking at paragraph 3 of the judgment.
2, but it's also in 3.
Also in 3. I was about to refer to paragraph 3, which records that there had been previous attempts at, it says IVF, it wasn't in fact, which failed. That there was then the joint application by the couple to be assessed as adopters, and a withdrawal from that process because the appellant felt at the time not ready to become a parent. And the learned judge then uses the words, the mother underwent further, wrong initials, IVF, and the child was conceived and born. It's also clear from the judgment, and this was another matter in relation to which evidence was submitted and heard, that throughout B's life, the mother, the respondent mother, has been her primary carer. That even when they lived together, the appellant's role was no more than, quote, to play a role in the childcare within the home when she was available. They lived together until December 2011, when B was 3.5 years old, and that since separation there has only ever been limited daytime contact. Since separation, again quoting from the judgment, the appellant has not played any role in the childcare or arrangements for the child's welfare. She's not played a part or exercised any parental responsibility. And Lady My Lords will have seen from the judgment that by the time the mother and B left the jurisdiction, contact was taking place every 3 weeks for no longer than 2 hours. In fact, B never went to visit the appellant at their house, still less ever have an overnight stay there or elsewhere with her after separation. It's also relevant, we say, that in the more than 2 years after separation, there was no application made under the Children Act. There was no attempt by the appellant to change, to vary, to regularise, as she would now perhaps put it, her relationship vis-à-vis the child.
Well, aren't people discouraged from bringing proceedings about the future of the children? Aren't they actually encouraged to try and solve it by agreement, even if one of them perceives that to be harassment?
Maybe they are, but...
So you can't blame somebody for not bringing proceedings.
Well, I've not expressed a value judgment yet, but the point, lady, is that the contact was taking place at the level that I've described. And in the time during which the appellant could have regularised that, improved on her position, that didn't take place. I would say it points, in fact, to perhaps a different motivation to that which is now apparent, or that which is now alleged on her behalf.
More specifically, what?
That it wasn't simply because the respondent, as the appellant would now have it, was cutting her out of the child's life that contact was as low level as it was. In fact, she had retired to a large extent from the life. She wasn't, I will develop this in due course, she wasn't acting at the time of departure as the child's de facto parent.
Of course, there is this letter that we've got at MS 722 that the appellant wrote to the respondent on the 29th of October 2013, picking up Lady Hale's point that you don't rush into family litigation. Isn't this the sort of letter that you would expect to be sent first, Mr. Tyler? expressing concern about the limitation of contact, expressing reservations about a court case, but saying that she may have no option if your client doesn't respond appropriately. What was your client's response to this?
Lord, I don't know her response to the letter exactly. Of course, we do know that there was a mediation session shortly thereafter.
Well, the mediation session was a charade, Mr. Tyler. It was all about discussions as to the contact that the appellant would have in this country in circumstances where your client had planned to leave this country with B.
My lord, the plans were already afoot by that stage, certainly.
It was a charade, Mr. Tyler.
Well, my lord, the other part of the learned judge's judgment, not subject of any application to appeal, to which I was about to alert the court, was her ladyship's finding in relation to the mother's motivation. She heard evidence, she heard it tested in relation to both litigants. Her finding was, her ladyship's finding, having recorded, as has been set out, the appellant's case, that the motivation was running away from her, from contact, from potential litigation. The finding was, I accept...
Just before you get on, sorry, Mr. Tyler, I'd like just to draw attention to, in a way, the judge is finding in paragraph 4 that the mother says she has felt harassed and frustrated by the applicant's continual texting, sometimes about contact and requests for contact, and sometimes just generally.
Yes.
Which is an indication that the judge may be accepting that the appellant did indeed want more contact than she was being permitted by the respondent, and the respondent was reacting badly to that. So that's before we get to the stage of this letter to which my lord has drawn attention.
I can't gainsay the fact that finding was made. The judge's sentence, I was, I think, halfway through.
Forgive me, I just wanted to mention
Not at
that
all.
before we got to the point you're at.
Have you responded to my suggestion? The mediation was a charade, Mr. Tyler.
Well, the difficulty in responding is that isn't a question on which I've taken instruction.
No.
And what I can, of course, say is that the evidence clearly shows by that stage the mother was well into the process of researching the move as found by the learned judge. So it must have been in her mind at the point of mediation.
By the time of the mediation, which was a bit later, that this was the case, what was her evidence about where she was in October, the previous October?
I don't think that evidence was tested in court. There are various passages in which the reduction in contact, the relationship, etc., are set out in the statements. For example, page 375. I'm so sorry, that's MS page 670 in Appendix 3.
Well, there's a rather fuller, for example, on page 761. It's quite clear the account is that the reductions in contact were all instigated by the respondent. I made a decision to reduce contact to fortnightly. Didn't like it being in the child's own home, so she asked for it to be outside the home. The appellant was continuously asking for contact to be reinstated. I was managing the contact. I decided to reduce the contact again to once every 3 weeks for 2 hours. So it's all the respondent considering that she's entitled to control and reduce the extent of the relationship that there was between the child and the appellant, isn't it? That's all in her own statement.
Maybe it may be convenient, while we're at that point in the bundle, to turn on 2 pages to a picture to which I would have drawn the court's attention a little later.
Oh, yes.
And this is really in response, it says so, my lord, it's page 675. I don't seek to draw a huge amount out of this, but in response to the suggestion that inferences be drawn about the child's perception from her use of the names she chose for the appellant and the respondent. This picture, which is October 2012, we see at paragraph 32, page 762, is October 2012. I'm not sure if I've yet got round to reading out the part of the judgment I was going to, that single sentence, which was this: I accept Mrs. Justice Hogg said her intention that she intended to create a new life for herself and for B in Pakistan. That being in direct response to the allegation that the learned judge recorded that the motivation was to run away from the appellant, from contact, and from potential litigation. Now, my lady, I wonder if I can note these facts as well. They're self-evident to those who've read the papers, but perhaps haven't come out especially clearly yet. Even without the benefit of that finding in relation to the motivation for leaving to Pakistan, it's important to note that it is the respondent mother who is B's only legal parent. It is she who is the only person with parental responsibility for her. She who was and is the only person with rights of custody, and the lady is perhaps questioning the reason for this. At the point of departure, more than 2 years after separation, the appellant hadn't acquired or sought to acquire rights, parental responsibility, or the like under the Children Act. We draw from that 2 things. One, I think, incontrovertible. At the point of leaving the country, the exit was entirely lawful. Though parallels are made with abduction throughout the papers, this was not an abduction. And the second point...
It depends on whether you mean it's a legal abduction in the sense of being a wrongful removal in legal terms, or whether it's an abduction in being the swift and, to some extent, concealed removal of a child from their home. Their long-standing, their home they've lived in all their life. It all depends what you mean by abduction. If you mean, was it an abduction contrary to the law, it wasn't.
Yes.
If you mean, was it an abduction in all but its legal characteristics, some might say that it was.
Well, my second point, I hope, was to address that. Whatever label the court, a member of the public, anybody, puts on the appellant vis-à-vis the child, from B's point of view, and whatever the reason, right or wrong, for contact being as it was, the person that B left, as she left the country, was somebody she was seeing for 2 hours every 3 weeks. Now, I
am still the grandmother of my grandchildren, even though I see them less often than that.
Yes, but the other distinction...
Merely make the point.
Yes.
Quantity is not the same as the nature of the relationship.
I draw out these points, which I hope are largely factual, in order that that when I look at habitual residence, when I look at parens patriae, we have a proper factual basis. I don't think the court yet has formally heard the frequency, the duration of contact. It is relevant to the child's perception, especially a child of that age for whom quantity is an important factor, as well as what others or the law might term to be the relationship. The chronology, specifically from the point of departure of the country, might need just looking at. It's 3rd of February, we know from the papers, 2014, that the mother and B left the jurisdiction. The question was asked earlier, I'm not sure if it was answered, it was the 9th of May 2014. We see in the chronology that the appellant was told via the mother's solicitors that they had left and were in Pakistan. There was a hearing on the 12th of May, because of course proceedings were already afoot. We see at page 605 in Appendix 3. The order emanating from that hearing, an order of Deputy District Judge Morris. The issues as defined in that order at that stage, it sets out at paragraph 4 under key issues that the child was conceived via that means, that the respondent is the biological mother, the respondents removed the child to Pakistan, and one of the issues then was deemed to be the family court's jurisdiction to consider the applicant's applications is at issue. And the directions set out for a transfer to the High Court, the timetabling of evidence and the matter to be heard. The statement prepared for that hearing is at page 660. Prepared by the appellant for that hearing. I flag this up because in due course, probably tomorrow, I'll say this is relevant to the question of whether or not the application is, in essence, going behind the intentions of the Family Law Act. But at the stage that this was prepared, about a month after the appellant learnt that B was in Pakistan, the statement records in paragraph 5 that a few weeks before having left the country, she had been hopeful there's a contact agreement acceptable to both could be achieved between them, and that was what the mediation was for. Paragraph 6, she sets out, in necessarily brief terms, her assertions in relation to the relationship, her involvement in early years, and her worry about the effect of loss of the family. Paragraph 8, her desperation to see and talk to the child since departure from the country. Worries that memory will be fading. And at paragraph 9, her concern about the attitude in Pakistan to homosexuality, it being, she says, illegal under Pakistani law, not tolerated. My grave concern would be for B's safety and well-being should the mother's sexuality ever be discovered. The inherent jurisdiction application isn't then made until the 6th of June.
Well, this is the 5th of June, I think.
Well, this is the 5th of June, so a statement in support, clearly, of the inherent jurisdiction application So I, in due course, will say that that statement sets out the concerns then held by the appellant, which justified her in seeking to bring the application one sees at page 608. Which the court has already looked at, which records at 613 the desire for a summary return and concern about welfare due to the removal to Pakistan. A return to England and Wales would also facilitate contact with her daughter, it says. Now, still just following through this chronology, laying down facts which I will seek to draw out in due course. One sees in the judgment at paragraph 8, MS 323. Mrs. Justice Hogg recording the circumstances through which the mother came to be served with the application. It proved, her ladyship said, to be very unfortunate. The service was effected through the parents of the mother living in this country. Up until that time, the nature of the relationship had not been spelt out to them. The grandfather, it is said, was very, very angry and upset and felt ashamed.
What's the explanation that your client has given for keeping their whereabouts in Pakistan a secret from the appellant and the appellant's family?
I mean, that isn't the matter about which I've taken instructions.
No, I thought not. Because obviously it would not have been a problem to serve her if she had told them where she was. But it was a problem.
Yes. The reason, I hope will become clear in due course, I made reference to that fact, wasn't to criticise the appellant, but to counter in due course the assertion that the mother is unable to live the free life in Pakistan, which she was in fact living in England, because it's clear that many of those around her didn't know about her sexuality, or state of sexuality, when she was living here. We would say that the recording by Mrs. Justice Hogg of the way in which she plans to live in Pakistan, in fact, wasn't dissimilar to the way in which she was living in this country. And it may be convenient just to alight on that paragraph because it gives more of an insight into the way in which the case unfolded before Mrs. Justice Hogg. At MS page 332, paragraph 33 of that judgment, having set out in the first few lines ways in which the learned judge thought the facts of Rie were different to the facts of this case. Her ladyship said it's not a question of the state intervening or even the applicant intervening to protect the child. The only issue that's been raised surrounds that of homosexuality in Pakistan. The mother tells me that she's living the life of a single parent. In the past, she's been cautious and herself circumspect as to who she tells or discusses her sexuality with. And greater detail in relation to her assertions are found in her statements at page 672. I'm so sorry, 736. In which she describes her reaction to the assertion that simply by being in Pakistan there is risk. into page 737 in the second half of paragraph 5. She expresses views about her rationale for moving to Pakistan, which were, of course, before the learned judge, but which bear specifically on the child's heritage and cultural identity, and, of course, language, morals, values, culture, heritage, matters which, of course, give the other side to the coin of that thus far expressed. Those then are various facts on which I will draw in due course. I wonder if I could turn just to look at the jurisdictional regime in slightly more detail than we have done thus far, starting with the 1986 Family Law Act. And the Law Commission report which predicated that act. That's tab 23 in Authorities Volume 2. And in particular, to start with, at page MS 1285. At paragraph 434 at the top, one sees two purposes set out there for the Act. Firstly, to replace the complications of the existing provisions with a scheme in which the bases of custody jurisdiction will be comprehensively stated, and in which the distinction between the bases of jurisdiction and the internal allocation of proceedings will be clearly drawn. And then recording of the fact that the new jurisdictional rules which we are proposing are designed to have effect on an international basis in the sense we've indicated. They're also intended in that sense to be exhaustive, so that the jurisdiction to make custody orders would have to be founded upon one or other of the four bases we have proposed.
Do they explain earlier, I must confess I haven't checked this, do they explain why it was that they were going to set out jurisdictional rules that would operate not only as within the United Kingdom, but between the various parts of the United Kingdom and the rest of the world?
We haven't seen that in these extracts, but they are simply extracts.
I realise they're extracts, it's a very long report.
Self-evidently.
But
I think-
the answer to my question is perhaps relevant.
I think there are a couple of pages in the report, not parts have been copied, which touch on that, but not in any extensive detail.
What is discussed in the report is the reason for seeking to exclude the nationality basis as being a basis for jurisdiction in custody matters. And one sees, for example, at paragraph 443, page 1287. At the end of that paragraph, furthermore, even where the child is a British citizen, it would seem that the circumstances of the case would have to be very special before jurisdiction were exercised on this basis. We had little hesitation in rejecting nationality as a criterion of jurisdiction in custody cases. Firstly, not necessarily point to a forum that's fair and convenient, and secondly, didn't point to a forum which could effectively enforce its order. And a fortiori, we thought the less easily definable concept of allegiance to the Crown in the absence of nationality was also unsuitable, culminating in the conclusion of paragraph 446. But importantly, at 447, the recognition is recorded that one effect of the jurisdictional proposals would be to remove jurisdiction from the High Court to make a custody order in wardship proceedings in respect of a British child who is neither habitually resident nor present in England and Wales. we don't believe a child in this type of case has a sufficient connection with England and Wales on which to found the custody jurisdiction.
Is there any evidence that they had considered the sort of situation with which we're now concerned?
Well, many know, in fact, there's reference, the page beforehand, to the scarcity of cases in which the jurisdiction has been exercised in relation to custody. Hope and hope.
What, the parents' patriarch jurisdiction?
No, wardship, as it was called.
Wardship, yes.
Same jurisdiction.
Had there been a joint consultation paper by the commissions, and if so, was that a topic on which they consulted?
Lord, embarrassingly, the answer to both of those questions is I don't know, but by tomorrow morning it's something I did know.
There's almost invariably a consultation paper,
Yes.
especially in a big project like this. But it's interesting, the context in which they're looking at this is interesting. Yeah. Yes, there's a reference on the previous page to their consultation paper.
That, of course, then was the precursor to the 1986 Act. It might just be helpful to look at that again, if I may. Tab 5. Sorry, I hesitate because I have duplicated pages. I don't know if Lady and my Lords have the same difficulty at the beginning of that section. But looking at page 847, Section 2, Jurisdiction General, in relation to a 1.1a order, and that, of course, is a Section 8 order. Any Section 8 Children Act order. A court in England and Wales shan't make it unless it has jurisdiction under Council regulation or the Hague Convention. It's perhaps too obvious a point to make, and of course it was also made before me by Lady Hale in A&A at paragraph 13, but the statute has been amended to include those two references to the Council regulation and the Hague Convention, both of which come after it. Presumably, in order that the jurisdictional basis domestically exactly mirrors that to which we have signed up internationally, leading me to make this point, that the primary jurisdiction in international family law clearly and firmly rests now in habitual residence. That is the currency of international family law. And if the word exceptional is wrongly used to denote circumstances, it's rightly used to say there's other bases of jurisdiction operate as an exception to that fundamental basis.
Of course, in international law, we are talking about in international treaties as between the parties to those treaties, with a rather twiddly bit in relation to Brussels II revised.
Yes.
But we're talking about as between those who have signed up to the 96 Hague Convention, which I don't believe Pakistan has.
Namely, but of course the Family Law Act doesn't operate to make that distinction.
Well, yes, it does, in fact. It does make that distinction. If the conventions apply, the conventions apply, and regulation applies. If they don't apply, it makes other provision. Section 3, isn't it? Am I completely misremembering? A court, Section 2, subsection 3, a court in England and Wales shall not make a Section 11D order unless either it has jurisdiction under the Council regulation or the Hague Convention, or neither the Council regulation nor the Hague Convention applies, but.
Yes.
So it makes separate provision as between the two.
Yes.
You could say that that makes it exceptional, but of course, there's quite a lot of the world isn't party to either of those two instruments.
The point I
Including Pakistan.
was clumsily trying to make is that the exception of, in that case, subsection 3b, refers to section 3, which then found jurisdiction in habitual residence or presence, if not habitually resident in any other part of the United Kingdom.
That's absolutely right.
So it doesn't say habitual residence in relation to international cases which involve countries which have signed up to the various conventions. It says if the conventions apply habitual residence, if they don't apply habitual residence. Or,
Absolutely right.
hugely importantly, physical presence. Because, and I'll come to this, of course, later, that is what allows, we say, what's been described as a devious entry through the back door, if a return order is to the court by the back door, if a return order is directed purportedly for other reasons, even if habitual residence doesn't vest in England, the court will have jurisdiction to make orders which, other than that return order, Parliament has expressly denied it the jurisdiction to do, and as my lady points out, with reference both to convention countries and non-convention countries.
Mm-hmm. You made an arresting and, from my point of view, a largely accurate suggestion 2 minutes ago, which is that habitual residence is the currency of international family law, Mr. Tyler. Would it follow from that that it's quite important that a child should have an habitual residence and not be in some limbo where the child has none?
Well, that could be answered in different ways. Firstly, I can see force in the suggestion that it is helpful for a child to have habitual residence. The examples that Reunite set out, I have said, are likely to be pretty rare in their occurrence, but clearly it's helpful. Looking at the Brussels II revised regulation, it doesn't much matter, because if there isn't habitual residence, then following the sequence of the regulation, there is a seamless code for discerning where jurisdiction will lie.
You mean presence?
Yes, in that code.
Well, presence isn't all that satisfactory a basis for jurisdiction, because adults can change the presence of a child so easily from one jurisdiction to another, and either gain a jurisdiction based on presence or avoid it.
Well, they can do. The question, which has occupied much of that which the court has heard today, is whether in doing so, the court in fact divests country one of habitual residence, and the circumstances of exit from the country, the motivation, etc., the factors set out in the various cases may well militate against the divesting of habitual residence in the first country. It's a point to which I'll return, if I may, when I deal specifically with Reunite's suggestions.
Thank you.
Because they make two proposals which, though I'm not sure they would impact hugely on our case, would represent a fairly significant change in the way these matters are currently considered by the court. Well, I'm glad that I made an apposite statement at least once in my submissions thus far. And I'm going to build on it while it's there.
The mention of one does not exclude the others in this particular case.
Habitual residence is the currency of international law. It's also, of course, much more specifically, the factor which would have entitled Mrs. Justice Hogg on the application of the now appellant to make the principal orders sought. It could have led to an order for return pursuant to Section 8 and to the contact, residence, any other orders which were sought. And her ladyship, after that 2-day hearing, came to the conclusion that the child was no longer habitually resident in this country. Again, in our submission, it's important to look carefully back at what happened at first instance in order to analyse the appellant's assertion that the judge was wrong in coming to that conclusion. The case or the criticism, it seems to us, that is made by the appellant is firstly that the judge misdirected herself in law. And that seems to be split into two categories. Firstly, that she wrongly took Re J as her starting point. And secondly, that in so doing, she failed properly to consider the other propositions which have come out of the far more recent cases from this court. Secondly, it is criticised that or having misdirected herself, she fell into the trap of assuming that the child's habitual residence would follow her mother's. And in doing that, she reached a conclusion criticised as being, quote, essentially derivative. Now, we say in relation to the first point, the misdirection in law, it is simply not made out. If one looks at the judgment, and I note and apologise for the fact that the court has already been taken to it in some length. But talking of the starting point is nonsense. I don't know whether my lady and my lords have penetrated the bundle sufficiently to see that when we prepared our skeleton argument for the Court of Appeal, as an appendix, we traced the inherent jurisdiction back to its foundations, which we say are in feudal times. The fact that we did that, the fact that we started 1,000 years ago, doesn't mean that that was our starting point in anything other than a chronological sense. And there's no sensible criticism of Mrs. Justice Hogg in making essentially the same criticism. She says, and I ought to say, though this wasn't extempore in the sense that it immediately followed an oral hearing, as I understand it, this judgment wasn't prepared in any detail, it wasn't given in writing, it was orally delivered and subsequently transcribed. So looking at paragraph 16, page MS 326, I now refer to the law which has been clarified in the recent past, starting with Re J. Now, clearly, whatever the punctuation would have been if one looked at it more carefully, what her ladyship was saying is that the law has been clarified in the recent past, which it has been by a series of cases from this court, and in looking at the law, she starts with Re J. And frankly, why wouldn't one start with Re J? Because it's the first case in time, and it's a case which then is referenced repeatedly in the Supreme Court, the recent Supreme Court cases which follow. So that she starts at that point can't possibly be a valid criticism, not least when the generalisations set out by Lord Brandon are immediately followed with paragraph 17, which says that observation was considered in the case of Rie, when both Lord Hughes and Lady Hale considered the matter. Now, more generally, it's said that this judgment is to be deprecated because it very largely repeated those extracts of law which Mr. Perkins had put in his submissions to the court. An alternative way to look at it might be this. The judge said, "What about Re J? What do you think about that?" Mr. Perkins expertly identified exactly what the judge ought to think about that, and it is those extracts that appear. Now, this...
These on page 327 at the top, these are Lord Hughes, are they?
Yes.
Yeah.
Now, I oughtn't to labour the point that this is an exceedingly experienced High Court judge, but it is, who only the day before or the day before that has been directed to and no doubt given copies of Supreme Court cases with which she is likely to be familiar in any event, and then reads into the judgment parts of those cases which she thinks of particular relevance. Now, it is a feature of cases, both of the European Court of Justice and of the Supreme Court, that large quotations from previous cases are included. So it's largely academic which case one quotes from, because each of those cases includes large quotations from the others. What we've done in our submissions is not the exercise that Mr. Williams did, which is to compare this to Mr. Perkins' submissions, but to draw out from the quotations that we do have those propositions which are explicitly recorded. It's at page 186 of the core volume. Paragraph 29. My use of italics, as well as making it that much harder to read, is to denote that it comes exactly from the judgment quoted in this form. And we have there A to M, 13 propositions, which we say comprise a pretty comprehensive, in fact, assessment of the law. Ending at M with, for example, Lord Wilson's description of the pre-CJEU law as being, quote, our old law. And then at the 14th point, Lady Hale's remarks in Re C explicitly setting out that it is a child-centred approach. It's the child's habitual residence in question, the child's integration. Each child is an individual. So we say that there's nothing missing from this. The fact that Re J, Lord Brandon, are both mentioned frequently is never with a view to saying this is the old law to which I, the judge, am wedded. It's always with a view to saying this is what the Supreme Court now says about that. If that's right, we go on to point out that the rest of the exercise her ladyship embarks on is equally faultless. Having set out those legal principles, derived as they are from those various different cases, she turns paragraph 27, page 330, to look at the facts and sets out those which to her seem particularly pertinent. Her ladyship received, I don't know, that morning, the night before, whenever it was, Mr. Perkins' submissions. They will have been in her mind. The ladyship doesn't need to set out each of those and specifically deal with it in order to disprove the suggestion that this High Court judge failed to take into account the submission made. What is set out clearly are those factors which she thought most important. Paragraph 28 has been criticised. Perhaps the only criticism is that whoever it was that transcribed this document set out the paragraphs in the way that they did. Having set out the general facts in paragraph 27, having made the finding at the beginning of paragraph 28 in relation to intention of the mother, but pertaining both to herself and the child, she made the finding on that basis, she, the mother, lost her habitual residence here. Faultless, we would say, not because Lord Brandon says so, but because in each of the more recent Supreme Court cases, it has been expressly acknowledged that a well-planned move can lead to immediate or virtually immediate loss of habitual residence. If one then picks up with the child's name on the third line and assumes it to be a new paragraph, one sees that her ladyship turns to look at the child, notes her age, notes who her home is, who her mother is, that the mother's been the primary carer, turns then to the child's perception. And of course, implicit in the acceptance both in the Lord Brandon era and subsequently, that habitual residence can quickly be lost, is the notion that even if one has a full life in a country, the process of packing up, of saying goodbye, and of intending in a planned way to leave that behind is enough to cause that residence to cease. And that's exactly what Her Ladyship says happened, not just of the mother, but also of the child. Now, in asking that question at the end, it is the desire to stay in touch with the applicant enough to keep her here. That's not a test that's being put out. That's not a reverse presumption. It's simply an acknowledgement of the fact that in the normal course of events, a young child's habitual residence will follow their parent. I'll come to that in due course. It's an acknowledgement of the principal objection raised on the appellant's behalf at the time, which is that she was leaving behind the appellant with whatever status and significance she had. And Her Ladyship then goes on to record that the wish to remain in touch with the appellant is relevant. It doesn't mean that she has to stay in touch in the country, because it doesn't, and we haven't touched yet on the notion of contact taking place in Pakistan. There are many children who stay throughout the world who remain in touch with families or members of the family or even friends when relocated. And the Ladyship records this is another relocation. Thus it is that the finding is made that not only did the mother lose her habitual residence, but so did the child. Now, the words used in criticism earlier were that paragraph 63 of RLC wasn't explicitly read into this. We say that makes no difference. The fact that there wasn't a broader inquiry was raised, but there was. This judge heard 2 days of evidence focused on 2 issues, and 2 issues only, in order to come to this conclusion. I hope I don't need in this court to labour too much the reference I made to Lord Justice Mumby's use of the words, there is a huge virtue in brevity in judgment, and that's tied in with the seniority of the judge. The fact that this judge didn't slavishly set out each of Mr. Perkins' submissions, dealing with each of them in turn, didn't set out every single extract from the relevant cases, is neither here nor there. Her Ladyship knew it was a factual inquiry, knew what the criteria were, and most importantly, knew that she was looking at the child as being separate from the mother, and came to the conclusion that she did. We say that cannot be criticised. We say that the criticism that it is derivative in its approach is not made out. The conclusion is the same. Not only did the mother lose her residence, but so did the child. But that doesn't mean that Lord Brandon's comments were being unduly exalted, because it ties in, for example, with the European Court in Mercredi. The case at tab 11 in volume 8. I'm so sorry, the case is in tab 26 in volume 3. The next case is tab 100 in volume 8.
Confuse the enemy.
Paragraphs 54 and 55.
Well, could you just give me the page?
I'm so sorry, it's 1469.
Thank you.
And the point is made, which is at once obvious, but also important. As a general rule, the environment of a young child is essentially a family environment determined by the reference person or persons with whom the child lives, by whom the child is in fact looked after and taken care of. Now, leaving on one side any judgment about reasons for the circumstances, as a matter of fact, the person with whom this child lived, the person by whom this child was in fact being looked after and taken care of, was the respondent mother. Even more true when the child is an infant, who necessarily shares the social and family environment of the circle of people on whom he or she is dependent. Consequently, whereas in the main proceedings the infant is in fact looked after by her mother, it's necessary to assess the mother's integration in her social and family environment. In that regard, the tests stated in the court's case law, such as the reasons for the move by the child's mother to another member state, the languages known to the mother, or again her geographic and family origins, may become relevant.
And then 56, the next paragraph, 4 lines down. To that end, where the situation concerned is that of an infant who's been staying with her mother only a few days in a member state other than that of her habitual residence to which she's been removed, the factors which must be taken into consideration include duration, regularity, conditions and reasons for the stay in the territory of that member state, for the mother's move to that state, and second, with particular reference to the child's age, the mother's geographic and family origins, and the family and social connections which the mother and child have with that member state. Now, were all those factors taken into account by Mrs. Justice Hogg?
Well, yes, they were, because those factors were exactly the same as those which were examined in analysing the mother's state of mind, the mother's motivation, the mother's intent when deciding to move. The mother is of Pakistani origin. The mother has all those things. The mother had a life ready for herself in the receiving state. But to quote again from the brevity...
She wasn't born in Pakistan.
No, it represents her
Well,
heritage.
it's her parental heritage.
Yes.
But she wasn't born in
No.
Pakistan. She'd been there once or twice, I think, beforehand, and of course most recently in the previous November.
She wasn't born in England either, as it turns
No,
out.
she was born in Kenya.
Yes, I take the point.
I mean, she didn't have a house lined up. She got that later. She didn't have a school lined up. She got that later.
Well, my lord, she had somewhere to stay lined up. She had a...
With a friend.
Yes.
Yep.
She had the right to move there lined up. She had a job lined up. And she had lined up the fact that she had to line up a house and a school.
Well, she lined up a school, but she changed her mind, according to her evidence, when she got there.
Yes.
I'm interested that at paragraph 50, the court referred to the transfer of habitual residence. And certainly the flavour of this is, appears to me to be, that the court is looking at indicators that somebody has changed their habitual residence from state A to state B, which is a little different from has lost A but not yet acquired B and is therefore without habitual residence. That although that exists a possibility, it doesn't appear to have been seen at any rate as the norm, does it?
Not as the norm, my lord, no. And in fact, I'll come to this in due course. The language changes with which the European Court of Justice deals with that issue. It's certainly contemplated as being the case that one can be left with no habitual residence for a period of time in that court, as it is still in this court.
Yes.
It's an exception, possibly. Whether it should be exceptional is, of course, whether it should be a requirement of exceptionality is, of course, a rather different question.
I mean, are you coming on tomorrow to paragraph 45 of the Advocate General's opinion in the slightly earlier decision of proceedings brought by A, Mr. Tyler?
Well, if I wasn't, my lord, I certainly am now.
Well, that's kind of you. It's at 1485 in this same bundle.
Okay.
It's tab 27. Now, this is the Advocate General. It's not the court. But here at 45, we see her saying, it's also conceivable in exceptional cases that during a transitional stage there'll no longer be habitual residence in the former state, while the status in the new state hasn't yet crystallized into habitual residence. Precisely for such a case, there's a jurisdiction on presence. Do you agree with that first sentence?
Well, forgive me while I turn it up.
Of course. 1485 MS.
Advocate General Cocotte.
Yes. Well, not exactly.
Also conceivable in exceptional cases that there'll be this hiatus.
Yes.
You do agree with it?
I agree it's conceivable, may I simply say, in cases that there will be that hiatus, whether the use of the word exceptional is meant to denote a test precedent to it being such a case, or simply a reflection of a fact, an assessment of likely frequency is a different matter.
Let's
It's going to
assume the
happen, isn't
latter.
it? It's going to happen, surely, as often as it turns out that there is no longer a habitual residence in State A, but not yet crystallised into a residence in State B. I mean, it's impossible to say how exceptional it's going to be unless this is put forward as a point of law. We're told it's not.
Well, that's exactly, my lord, the point we make in our written case, which is that it is a question of fact, habitual residence. So the factual assessment is applied both to country A and to country B, and the answer will be the answer.
I know it's constantly said it's a question of fact, but I do rather wonder about that, because one's got the judgment in Mercury, the opinion of the Advocate General, we've got the various authorities of this court. I mean, is there not a legal concept in the idea of habitual residence?
Well, I'm concerned to hear that because we describe that as the only authentic principle that can be derived.
But there isn't there's no legal principle.
Is the only authentic principle is that it's a question of fact. But, of course, what one is deciding as a matter of fact has to be defined in some way.
And I mean, the way courts are sometimes in the habit of saying it's all a matter of fact, and then they lay down guidances, which to most people would seem like indications of a legal concept.
Well, I entirely agree, in fact, and we will say in due course that what this court's being invited to do by the appellant, and more so by Reunite, is to remove one, to adopt Mr. Williams' analogy, layer of gloss, only to replace it with another.
Right.
But when it comes to this, habitual residence, another decorating analogy, doesn't quite do what it says on the tin. One has to define the words in some way, define the concept in some way. That is what the European Court's done, is what this court has done recently. But of course the danger is the moment one goes beyond the most Spartan of descriptions, that which one does say is taken to be a legal rule rather than what's intended to be a helpful observation for those judges and practitioners who have to apply the test.
Is that a convenient moment at which to pause?
In the sense that it's 4 o'clock, yes. In the sense that I haven't got as far as I'd hoped, then no. But
Could I just ask you one question before you do that? What happened? Do we have the decision of the court in this case? In A? In Advocate General Cocotte's case?
Yes.
And which, can you tell me which it is?
Follows on seamlessly, doesn't it, Mr. Tyler?
it does.
In the same.
At 1491. And the
I beg your pardon. Thank you very much. No further questions.
Well, I'm sorry that we've been interrupting you so much, and you did have a slightly late start as well.
I did, my lady.
You did.
I might retake those few minutes when my friends
Don't,
reply.
Don't imagine that I hadn't noticed.
Thank you.
I will hope very much that the start of our proceedings tomorrow afternoon will not be delayed, but because I am at an event at which royalty will be present, it may be harder for me to get away when I want to do than it would otherwise be, though I trust that I will be able to be here by 2 o'clock. But if we are late, well then certainly, speaking for myself, and I would have to consult my colleagues, I would certainly be prepared to make up the difference at the end of the day.
Thank you.